Bring back in Michael Binetti, managing partner of Affleck Greene McMurtry LLP, and also Richard Leblanc, professor of governance law and ethics at York University. As we await now for this delay that we've had, but we're coming up on the hour when they should be getting to business in Vancouver. Michael, I want to start with you in terms of just resetting the table for our audience in terms of what is here. I mean, this is Edward Rogers going to the court in Vancouver and basically saying, I would like you to make a declaration that I am fully within my powers and my rights to dismiss those independent directors, put the people I want in place, and make the changes I want. What does this case look like from your point of view?
Yeah, he's basically said to the court, I could have done this all along. I've done it, and really, there's not much many people can do about it. So he's coming at it from that angle, which is this is perfectly legitimate, and there's nothing untoward, and this is what happens in corporations or companies that are held essentially by one family or that are very tightly held. So from my angle, that's, it seems that that's the obvious argument that was made, and the counter argument is that there was some notion of procedure, but they've also woven in an idea that you need to act with, in good faith and whatnot in discharging that duty that or those rights that you say are so strongly in your favor. So it's an interesting dynamic between the two angles. Now, I think Edward does have the upper hand.
Edward has the upper hand. We can find out very soon what the judge thinks of that as well. Richard, I wanted to ask you, as part of all this, it seemed like, hey, we're going to have the articles of incorporation, the rules as they are in BC, where the company is incorporated. And then you started getting some filings from Loretta Rogers in terms of what the late Ted Rogers wanted, what his wishes were for the company. As you read through those, did that change the story at all from your point of view?
It did. And I agree with Michael and your other colleague that Edward does have the upper hand if it's a narrow read of the law and what is in the articles. If the judge allows other thoughts to come in, such as good governance, such as Loretta Rogers, such as Ted Rogers as settler of the trust, then we could see a different result. We could see, for example, that Edward Rogers has to have a meeting. We could see a lot of things. It depends on where the judge goes. So a narrow interpretation is, yes, he's got all the marbles, he's got all the votes, and he can be king of the castle. A broader interpretation is that he can't. This is a very high concentration of power. You at least have to have a shareholder meeting, and we'll see what happens.
Michael, on that point, if we do get a broader interpretation from the court, from Justice Shelley Fitzpatrick, what would that mean in terms of broader influence? I mean, we would talk about a decision in Rogers versus Rogers, but what could it mean for cases going forward as a precedent?
Frankly, not much, only because the article that everyone's fighting over has this trailing notion, this line that says at the same meeting, which is funny because the BC Corporations Act doesn't require that kind of meeting if you're going to exercise all of your shares at once. So I think not much turns on this when it comes to pointers for other companies to take in terms of governance.
Richard, what does it say to shareholders, though, if Edward Rogers does prevail in this, in the sense that he holds all the cards as being chair of the Family Voting Trust? You have people holding shares that don't have any voting power whatsoever. I guess the argument is they can take part in, I guess, the successes of the company through a rising share price, but they don't have a say in anything else.
Well, that's a good point, Greg. There's a saying in governance that it's the founder's way or the highway, and independent directors that I interview, they tell me when they're on control trust boards and family boards, they really don't have any authority. They can just cajole, they can advise, etc. So as a shareholder, and don't forget, 70% of the shareholders of Rogers are retail shareholders, and they don't really have a say. So this might cause some scrutiny of dual class share structures, of control trusts, of Corporations Act. If we had a national securities body, we probably wouldn't have a potential race to the bottom in British Columbia, where we have this anomaly where you can vote by resolution and you can avoid a meeting. So I think this case, a little broader, is raising some questions about should one person have all this power. And you're really, if Mr. Rogers in the next few minutes is successful, you're really betting on Edward Rogers. You're not betting on the company. very similar to Facebook. I mean, you're putting all of your eggs in the founder's basket, and that sometimes can be risky if you have a falling out or if things change.